Еще раз доброе утро, уважаемые участники форума.
Good morning once again, dear participants. I am glad to welcome you at this forum, even though this is not the first International Legal Forum, but this one is unusual, because as you know, usually in the beginning, the forum was opened by the President or Prime Minister Dmitry Medvedev. This year, the organizers have decided to change slightly the format, and the first 2 days will have active discussions, and the plenary session will take place on Friday, where we expect to see the Prime Minister. I do not think this will impact our work and the discussions and presentations that we will hear today and tomorrow. So I'm happy to welcome all of you here, despite such a cold St. Petersburg weather, and here in the general headquarters, hopefully you will feel comfortable. I'm happy to welcome experts of world-class experts in infrastructure, both representing both consultants and the legal profession that work and service major corporations that do the construction and operation of infrastructure. Our topic, just as last year, is similar. I am traditionally moderating sessions about the legal support for infrastructure investment, and whereas last year and the year before we discussed PPP, this year we decided to have a session with a broader focus without limiting to the discussion of public-private partnership, even though we will definitely touch upon this area as well. But we also would like to discuss infrastructure bonds, syndicated loans, and the project financing practice in general, with the focus on infrastructure facilities in transport, public health, raw material transportation, and other infrastructure facilities. Let me first give the floor to Denis Kochkin, managing partner Kochkin and Partners, known by his practical involvement in the key projects of construction and operation of infrastructure. As you're aware, we've had quite a few changes recently in the legal regulation of investment in infrastructure, including the law on the contract system, which introduced some serious changes in state orders, introducing such notions as the life cycle contract, long production cycle contracts, as well as changes in the concession law, and I hope Dennis will tell us about the amendments planned as promised by the federal authorities long ago. So Dennis, could you please tell us these recent changes that the legislator has adopted, what impact do they have on the practice of infrastructure construction, the practice of long-term contracting? Are there any contradictions between the various legal models of financing the infrastructure, both on the part of the government and private investors? Aleksey, thank you very much for this opportunity to speak, because indeed recently legislation in the area of PPP has been changing dramatically, and all of you present here are well aware that a year ago the first reading of the PPP law was adopted, the federal law, and as far as I know, yesterday the second reading took place, but judging by the absence of any press publications, most likely it ended up with nothing in the State Duma. So we're all looking forward to another reading that will change the concession law, something I'll talk about a little bit today in my presentation. Actually, this session is devoted to the financing of infrastructure projects, and I will discuss a fairly new instrument that has now taken this legal shape, even though it's not new itself. This is about life cycle contracts. Life cycle contracts, just as investment contracts, are an actively used instrument, and it's not a legal but a rather economic category, which has a certain traditional meaning to it. It's a contract form of PPP. It's a contract according to which the governmental partner assigns or orders, while the contractor accepts the order to build an infrastructure facility and operate it for the entire life cycle. And the public partner finances the establishment of the facility, its operation, in a form of service payments in equal installments approximately once the facility is commissioned. And payment is based on the given functional requirements as set in the contract. I have described the traditional understanding by the officials and market players of this instrument, the way it can be seen in the legal, from a legal perspective. What's important in this definition is that the private partner undertakes the design, construction, and maintenance. Besides what they do, they decide on their own on the technical and project matters, and are responsible, assume the related risks. The private partner also raises financing for the project, while the state partner performs the payment starting from the point when the project comes into operation. Payment includes maintenance and, like I said, the performance of some specific functional requirements as said in the contract. The key advantages of this instrument for the construction and operation of infrastructure facilities are that the private partner is motivated to perform on their obligations promptly because the first payment is based on the time on the commission point in time when the facility is commissioned, and quality because if there's poor quality, the contractor will get paid less money. This slide shows you, I hope you can see it, this is a overview of the LCC contract, and let me discuss the legal nature as understood in terms of the Russian law. Trying to understand this, you have to remember the definition of contract, which under the Russian law is where the parties are free to enter into any agreements unless contrary to law. So LCC, life cycle contract, is a mixed contract, Article 31 of the Civil Code, and it combines the elements of various contracts, including those of supplies, services, depending on the legal relations chosen by the parties. Now, the conclusion that is asking itself is that this is regulated or should be regulated by the civil code. But this statement is only true for LCCs between private partners. And if financing participation of the state is involved, then you have to look for different procedures, special procedures for this type of contracts that will make sure that will enable the spending of state funds. Let me briefly illustrate for you to have it clear, because we have here today representatives from foreign jurisdictions. This contract, in terms of the legal tradition, has various names and is and exists in various jurisdictions, like design, build, finance, and maintain. There's quite a few examples to it. A couple of examples are shown on this slide. The A15 route in Holland, then a highway in Calgary, then highways in France, motorways in France, and many other facilities that involve major investment. But these are most transport DFM contracts. Besides, there's many names and life cycle contracts. Well, our Nordic colleagues take pride in this. We have one in Finland. The E18 Turku-Helsinki road was built for 303 million euros, or 354 million according to the initial estimate. And they have even calculated the contractual efficiency, which was about 50 million euros. Besides, LCC contracts are often used in the UK. The private finance initiative, as they call it, unlike the concession. And it's actively also used in public health in the UK. Despite the fact that the LCC contract as a legal instrument has taken shape very recently, de facto and de jure such projects already exist here in this country as well. Let me note the classical LCC in St. Petersburg. There's 2 contracts made, and the projects have been built already. These are social facilities, schools, kindergartens in St. Petersburg. Then a complex development. And then, and last year, a contract was made to maintain and ship carriages for the Moscow metro. And finally, a concession project can be cited, because recently an instruction by the Prime Minister of the government was published. The Central Ring motor road in Moscow, 50 kilometers long, will be built based on a concession contract. It'll be fairly capital-intensive contract, 5 billion rubles. The history of LCCs go back to the system of state orders that tried to bring together the various types of delivery, construction, maintenance. But the Federal Anti-Monopoly Office tried to stop this, to prevent illegal competition. And under Law 94, we did not have any successful contracts. But then the St. Pete Law was adopted in 2006 that extended the PPP area to include a large areas of legal relations. And then in 2012, even though the law itself on concessional agreements was adopted in 2005, but in 2012 we had amendments adopted to the concession law and the law on Russian motor roads, which permitted making LCC contracts as part of the concession model. These have been fairly significant changes. Payments were envisaged for public partners, but for the time being only for one field, for the automobile, for the car infrastructure.
In 2014, quite unexpectedly, we had an unexpected provision in the federal law on life cycle contracts. It was really a surprise for many of my colleagues, and they were convinced that they had been convinced that the concession model would be made the basis of it, but what we got is what we got, and we are living in a new reality under the federal contract system. We have analyzed the government procurement website, and last January was the first LCC tender under Law 294 for the construction of 180 kilometers of highway in Khanty-Mansiysk district with 3 phases, and it runs up to 2020. But the LCC criterion is missing from it, but I will get back to it later. So what do we get if we compare the two legal models, the FCC system, federal contract system, and the concession LCC, a concession type LCC? Now, the object of agreement under the FCC contracts are defined by a government resolution and covers the transport infrastructure, highways, railroads, subways, also entities of the municipal economy, and unique capital construction projects. The concession model covers a longer list of projects, including public health, education, culture, sports, tourism, and social projects. But the mechanism of LCC financing only exists with relation to the transport infrastructure, but we expect amendments to the concession law 115, which will give a list of concession projects, and then it will be broadened to all types of entities and projects. Talking of the functions delegated, then there's a collision. Within the framework of the contract system law, the provision is that for a life cycle contract, the mandatory phases are design and construction, should be followed by subsequent maintenance and, if necessary, operation. But if you take the government resolution that defines the possible cases where FCC contracts can be applicable, we will only see works by way of design and construction, say, of highways. The only project on the posted on the government procurements website also provides for maintenance, and this is something that may attract the attention of government oversight bodies. If we take the functions listed in Law 115, it also includes the phase of operation, but it may include various functions. As far as I see it, the way I see it and the way my colleagues see it, it's purpose-oriented operation, whereas services and maintenance are obligations of the concession holder under Law 115. There are differences in the composition of public and private participants. If you take the public side, then under Law 114 on LCC, there cannot be multiple entities on the public side, and it should either be a government authority or the government corporation Rosatom or a budget-financed body, or and as regards the concessional part, well, the participation of government bodies and offices is allowed, whereas certain rights and duties may be delegated to individuals and third parties. As regards the LCC system, then on the private part, consortiums or simple partnerships are not allowed, which really makes it more complicated, because under complex infrastructural projects, groups of entities are normally created because not all competencies are combined in the same entity. And I think that's a limitation. As regards the planning of procurements and project preparation, there are differences. Law 114 provides for a complex and multi-stage procedure, including not only planning and all kinds of timetables, but also the initial and maximum price of the contract. In the case of the Hanti-Mansijsk contract, there's a provision for the initial price taking up 25 pages. As regards the concessional type, there's no such formal requirement. Then the financial participation of the public side, there's a shortcoming in the federal contract system law, because it sets the limit of budget obligations or liabilities on the FCC contracts, which may not range longer than 3 years, whereas the Hanti-Mansijsk project will reach as far as 2020, and agreements on changes in financing terms may be made, but beyond the limits of budget obligations, concession makes financing possible. And it is very important for infrastructural projects to be able to incorporate price adjustment for inflation under the FCC FCS, it's so far impossible, although concessions are actively applied. Now, titles to projects is an important aspect of these contracts. Under a concession, the title to ownership and use is mandatory. The transfer of that title is mandatory. Under the federal contract system, no such right arises. Those titles provide certain guarantees for partners, and of course projects where property is in the ownership of a private partner are more attractive, and it's only in PPP projects that this is then attractive. The possibility of complex projects with multiple components is also important. It is necessary to explain the presence of a technological relationship among items of property as part of the agreement object, or multiple entities are permissible only within one group of entities, and all kinds of purchase procedures like tenders and bidding contests are broader than the federal contract system. There's no practice so far. It's not clear how it's going to be used, but in the concession model, this has been tested already. It's a two-phase bidding process with tentative or preliminary selection and allowing negotiations after the awards are given. And it's important that the FCS provides for the possibility of additional financing under direct agreements with lending organizations, which reduces project risks and reduces the cost of financing. Under the FCS, it's impossible. Under concession contracts, it is possible. And talking of key project risks, there's a disbalance in the government procurement system. A part of under the concession model, part of the risks may be transferred on terms defined by the agreement, and it all has an impact on the cost of financing. This also has to do with the liability of parties under the federal contract system. The penalty for failure, for non-execution, is defined by the law, and enforcement is mandatory, whereas under concession contracts it's defined, determined contractually, and there may be an out-of-court termination, whereas under the federal contract system it's mandatory to terminate a contract in court. Now, if terminated under a concession agreement, banks will return their money because the private partner will be reimbursed for its credit costs, which is impossible under the federal contract system. The law does not provide for that. So the investment attractiveness of contracts for external investors is extremely low today under the federal contract system, so we don't expect many FCS contracts to be concluded. So in practical terms, I don't think it's a very pleasant fact that when preparing such projects, life cycle contracts, we always appraise the legal risk of requalification from FCS to government purchases, from a regional PPP to an FCS contract or a concessional contract, and the more dualities there are, the higher the risks. So it is still unclear what to do in this situation, and practice will show. Thank you very much, Denis. You have raised indeed a very important issue of the practical value of this novelty in the federal contract system law. As a financing organization, we, as one of the few banks that finance the infrastructure and various models, including the concessional model, the regional PPP models, and the contract system, we are really very apprehensive about those new life cycle contract formats, and the main concern of ours is that being a totally new tool for the federal law, already now there are contradictions between Law 114 and the government resolution, as Denis has mentioned. On the one hand, the FCS is defined as design and operation, whereas construction and operation, whereas the government resolution only allows for design and construction of highways. And the projects that regions want to make, and according to our practice, regional authorities are really very keen on channeling out-of-budget investment into the infrastructure, including highways, and their task is to use the investment that the government budget makes in these projects, and they are interested in projects where projects are not only built but also maintained and operated, whereas the budget pays for it in the long term, and this really reduces the load on the budget, now stretching it over longer periods, and it's really a very pressing issue for regional budgets to extend those periods of budget investments, and it might appear that the law would allow for that, but in practice it only increased the risks and aspects that are still not clear, because there's the risk of requalification into a contract system where the life cycle contract instrument has emerged, but it is impossible to use it because there's a contradiction, and because there's a limit of 3 years, and the 3-year period for installments is something that regional budgets don't need at all. So everybody's saying that something has to be done for the infrastructure, but those contradictions are really viewed with a lot of concern by investors. At the same time, we have government companies, state companies, and ministries which actively resort to contract obligations, including all kinds of concession and mixed contracts, and I mean here the Ministry of Transport and the Avtodor state company, which were pioneers in structuring deals associated with investment in the infrastructure, which had traditionally been financed by the state. And now I'd like to hand over to Konstantin Popov, who was one of the authors and supported the largest project, that of the Western Expressway. This is now a road in St. Petersburg that anyone can drive on, and its construction continues. And Konstantin has supported it on the part of St. Petersburg, and government and full ownership of the St. Petersburg government. And now one of the senior executives of Rosavtodor, which is the leader, as you know, in announcing tenders and implementing projects that are viewed positively by all external investors in terms of infrastructural investment.
Konstantin, I understand that you have some news and new forms of implementation of projects that are related not to Law 44, but to other forms of legislation. But my first question, making a link with the previous conversation, my question is, how do you see evaluation of mixed-type contracts? What about long-term investment agreements that Rosavtodor uses? Because there's no direct regulation for them, and the federal regulator tries to introduce that. Now, how do you evaluate the future of new projects that Rosavtodor is going to launch in the near future? What new models do you see? What will be in demand for the market? And how are you going to implement these new projects in line with the changes in legislation? Good morning, dear colleagues. Thank you very much for this introduction. I was holding my breath and responding to your kind words. I should say that this pilot project, the road we can all drive on now, this project was possible thanks to a little bank from Russia, and they helped a lot. Now I represent Rosavtodor, a company. Mr. Chichkanov mentioned that we are pioneers in the area of construction of infrastructure projects, and this is our mission and one of our goals stated in the Charter. Yes, so we have a very big pipeline of automobile roads projects. This is reconstruction of the existing federal roads, and one of the most significant things is attraction of financing for construction of new roads, and the Central Ring Road Dennis was speaking about, and I would like to clarify the first part of this ring road. It was not a concession. However, we wished for it. And returning to the question Mr. Chichkanov asked, as investors always ask, what are we offered to invest? And although the concession law has existed for a while and all possible mistakes have been made and advantages and disadvantages of this law are familiar, and the state company views this concession law as a priority when a lot of funds need to be attracted. This is in relation to the overall volume of capital financing, and about 10–15% of non-budgetary funds. This is possible to attract through long-term investment agreements. And thank God, Federal Law 44, we don't work under it, so we follow another law, 223. So the full-fledged project financing if we need to organize it in this area of legal uncertainty, but only following Article 44 of the Civil Code, of course, it's a great challenge. And when we speak about a need to attract more than 25% of attracted funds, here, of course, we speak about a concession agreement and everything related to it. So there should be an order from the government and then preliminary qualification and bidding. And the market already knows that it is possible to organize project financing in line with this law, and a number of first deals that have been closed already, or closure of which is quite close, they make a proof for the market. And as for the novelties in legislation, I would like to speak about this is, for example, bank support of PPP projects. This is not only the task that public companies or state-owned companies have. Actually, it is an indication of the possibility of this support, and it was included into that law, Federal Law 44. And in the order of the government, it was stated that all projects of the Federal Ring Road, they should have this type of support. And in this case, we, Rosavtodor, became a pioneer in this area, because the methodology of how this should be done doesn't exist, because there's nothing about it in Federal Law 44, because they refer to decrees of the government. So these are normative acts that is supposed to regulate the support, but this normative act doesn't exist. We know that it is under discussion, and approvals are being prepared. The draft act was prepared by the Ministry of Finance. We analyzed this draft order, and we saw that the majority of questions that arise, you won't be able to find any answers in this document. So this means that all these answers should be found in learning by doing. So as soon as you try to do something, then immediately you face lots of questions that should be referred to the government. The questions are that the state company should ensure a comprehensive service, so banking support together with the state oversight of the construction works. And the ideology is quite clear. The state, by investing in its own infrastructure, doesn't feel very comfortable in the situation when the oversight of all spending will be done by the investor. The state would like to have a certain leverage and understanding where this money is spent. And the projects where Rosavtodor introduces this banking support is the central part of the Federal Ring Road. And this is due to chronological reasons. It was the first section to be built. And we had quite detailed and expansive consultations with the banking community and with representatives of the engineering companies, with the leaders of the infrastructure construction market, and it turned out that the problems that exist, they are all of legal nature. And the first of them is that different participants of the market are different, in terms of their competences. They are not ready to be responsible for each other. For example, a very simple thing, when a banking company signs a subcontract with an engineering company, in a situation when we speak about big potential areas of responsibility and liability, political and financial, because of course targeted financing of budget funds, this is something very tangible in the end. So the market, yes, and this is within the criminal law. Yes, and of course, and what we see in the civil code, that the general contractor is liable for everything is done by subcontractors. They said, no, we are not ready for it. The second problem that immediately arose is how deep this banking support should be. For example, how many levels of a subcontract should be covered by this support. And here, of course, there are very different opinions. Subcontractors, they say that, yes, you should have this responsibility only at the level of the general contractor level. Then the government is saying no, this is wrong. This oversight and responsibility should stretch to supply of all works and materials up to 500,000 rubles. This means up to the last nail. And here we faced a very interesting problem. One of the workers of this bank I mentioned, he said that this is a curve of indifference. This is a triad that consists of, so in one corner we can imagine the level of control the client would like to preserve in any construction project. Then the second corner, this is the security the client provides when they say that they will build this project within a certain time frame. And the third corner is the cost of this support and oversight. And we expected that we have to choose two out of these three things, but the market said that if the state would like to have a greater level of control in the construction project, and at the same time the government doesn't want to move its position in terms of the securities it gets, and this is 10% of the capital construction cost. If it is a concession, then 10% is only that part that the concession holder would like to have. And financing companies, they would like to have about the same. So this can be 5, 10, 15 billion rubles. Yes, in absolute numbers, these are very big volumes. And for contractors, this is a lot, to put 20% of the capital construction as a security on the account. And the practice demonstrates that this should be a bond from a well-respected bank. And after that, being a general contractor, not to have the full control over all spending types within the project, and at the same time fulfill the obligation to complete construction works within the specified time frame. This is a serious challenge. So right now I can say that there's no final solution to all these goals. And as I said, this was just the first thing that we had, and now we announced a tender, and there's a great interest from the market, but we realize that this practice is in the stage of forming, and we cannot ignore this thing, banking oversight of large infrastructure project. As far as I remember, in the May order signed by the President, there's a certain clause on that, and that is why it has been included into this Federal Law 44. This is a new reality we are all going to face. What legal solutions will be provided for this dualism between bankers and engineering companies? We hope that we managed to find a certain solution. In this this particular case. We proposed, as Denis said, you cannot have multiple faces in the public area, but we follow not Law 44, but 223. And the construction, the structure we are offering, and we believe that the market is quite responsive to that, is multiple faces on the part of the party responsible for construction works. So all applications, and in the end the agreement for this comprehensive service should be signed by two parties. Denis was saying that LLC is out of question now. I'm not sorry for that, because we all know from our practice this was not very well functioning structure. Nobody wants this solidary responsibility. And when we consider this offer, we believe that this is a good answer to the challenge we faced. And I hope that it will work, and we will get a lot of applications from the market. And I don't want to take much time from other speakers, but I believe that this is a serious challenge, and the legal community is facing it. This is important for these large projects. Now, the state says, I want to take part in cash management. The state is not happy if only financing organizations do that. And first of all, it covers projects under Federal Law 44, where there are actually no financing organizations. So the state gets actually unified right for this cash management, and I don't know how this will affect distribution of risks in agreements, and maybe the contractors' responsibilities in terms of time and works, maybe it will become not so clear. So we will see it in the future. Thank you, Konstantin. Yes, in fact, those questions that the market has to the new norms of the federal legislation, thank God, you don't have to deal with them, but at the same time, those requests and demands from the state, especially in terms of large infrastructure projects, the state requires from companies. This leads us to a situation when new mechanisms and new competences in the market. We, within our bank, we consider very seriously participation in bidding for this oversight. This is a new area for us, and we consider very carefully whether we need to take up all risks related to engineering oversight and checking whether all costs are well justified. Even if we have a special division devoted to that, I don't think that banks are ready to do that. And if you propose this shared responsibility, and there are several entities signing the agreement on the part of the concessionaire, this may work. And now I would like to move slightly aside from our quite a patriotic discussion of our difficulties. I would like to give the floor to Marco Della Vedova, who is a partner of a law company with the same name. It is Studio Della Vedova. Marco, I would like to ask you a question. You are well known. We know that in Italy there are lots of projects, lots of infrastructure projects, and roads have been constructed with the help of attracted financing. I know that there are healthcare projects that are built and operated by private companies. We, within our bank, we would like to have a partnership with Italian companies who are well known known as concession companies in the area of healthcare and social welfare. Marco, I would like to ask you, what is the practice of project financing? How do you attract funds into infrastructure projects? Are there any difficulties or do you have similar difficulties we have been discussing? So what about Italy?
Aleksey, participants, panel. Thank you for having asked me to be here. I'll try to reply in brief, given the short time that we have available. We have a few models in Italy that I think are of great interest. Just a few data and a few comments on what has been said. We have a highway infrastructure financing that's arguably the largest in Europe. A number of models applied to public health and public-private health that have been going interestingly well. Tuscany, Mestre, near Venice. The fact that there have been a number of litigation, both civil and criminal, should not distract by the validity of the underlying model. Today, I would like to concentrate on one kind of model that we've been applying in project finance that I think does represent a platform that can be adopted in a number of different jurisdictions on the basis of certain assumptions, and does strongly incentivize the promotion by single and or combined enterprises of project finance in so-called unsolicited offer environment. So what are we talking of? Assume I want to promote, I'm a major construction company, I want to promote the building of a highway, of a trade of a highway. I promote, and there is no tender out, I promote to the relevant public administrations of the single area I'm interested in. So let's assume Milan, Turin. There is already a piece in, but let's assume that's a scratch operation. If I am acknowledged as promoter, that will take 1 year, 1.5 years, then a public tender is out, and if I win, I win. If I get second, I have a first refusal right to match the offer of the awardee. So if I won, I walk away with the project. If I am second and the first one offered 80 points and I came in second with 60 points, I can match the 80 points, put on the technical and economic integration, pay the cost of the temporary awardee, and result to be the final awardee. This is the scope of my discussion today. Basically, there has been a negative approach to unsolicited offers in a number of jurisdictions, in many common law jurisdictions. I strongly have a different point of view on the positiveness instead of an unsolicited offer, based on two main considerations. One, the difficulty for a public administration to match the timing of what's needed. Second, the difficulty for the public administration to pull out in a timely fashion a financial package for a certain infrastructure at the good and correct moment. So the key points that, of the package are basically what should a promoter be proposing, what are the contents of the package, and what is the immediate procedure. What is the package? Promoter comes up with a public project, and we'll see what public means, with a financial and technical plan, a draft of a concession that the promoter writes down, a draft of a financial economic plan, a supporting, at least 2 supporting letters from major financial institutions, and the willingness to provide a bond. When I say public, this full package is made public because it's filed with the public administration, be it the region, the central government, or association of local municipalities, is analyzed by the public administration. Public administration can say, I like it, and you're going to be the promoter of this project, of this highway. I do not like it, you go home. Or I like it, but you need to amend it. So if you want to amend, you amend. If you do not want to amend, you go home. So assume the procedure goes on, either you're appointed or I like it, but you need to amend, which is what usually happens. After a first period of 1 year, 1.5 years, you're appointed as promoter. At that point in time, there is a decision, a second decision of public administration to issue a tender. The tender will have the object of the construction of the highway. The promoter participates. All other interested parties all over in Europe, typically on a European tender base, do participate. And the result, again, as I mentioned before, it can be either the promoter is awarded, and there is one specification I need to insert. When the promoter files in the tender and when the others file in the tender, they need to specify the cost of the participation. On average, on such a project, we're talking of something between 700,000 to 1.5 to 2 million US dollars. So once those costs are defined and closed in an envelope that has been filed, then there is the opening of the envelopes. If the promoter is awarded, he retains the project. But let's go to the prospect that we have seen before. When assume the promoter comes in as second, the promoter can, and there is an interesting conflict of interest to handle here. Either the promoter says, I'm going to offer more and match the offer of the temporary awardee, so I'm pulling out some more financial resources and additional bank guarantees, and I file them in a short time frame, and I pay the cost of the temporary awardee. So the first company is temporary awardee, is $2 million cost. I pay $2 million. I need to squeeze from 60 points up to 80 points. I need to squeeze my bank guarantees from 60 to 80. So I do these three things. Then the temporary awardee leaves. He's paid, his costs are recovered, and I am at that point, the final awardee. The other chance is, yes, maybe I have a chance to match the first one. It's difficult. I've won a different contract, a major contract 2 days ago. This thing has been going along for 3 years. Too many resources. I want to walk away. So the temporary awardee is going to pay $2 million to me. So I went through a lot of time and expense to build up this project. It took me one van to do the filing, because those were 8 boxes. It took me 3 people to take all the boxes up to the 8th level of that skyscraper to do the filing. And it took me a lot of time and devotion. And so I'm reimbursed of those $2 million, and I'm concentrating on those other projects I won 2 days ago, and or for other reasons I need to concentrate on. So still the key issues and the key points in such a projects are, and this is what I would like to get down to, is once one agrees with the principle of this, A, conflict of interest. I can do, but I need to be careful. The second one can come in, but the temporary awardee can do, but there is this other possibility. So there is a lot of balancing there. There is a publicity, there is advertisement, there is a European Gazette, there is a national public manchette published on the national newspapers. So there is full transparency. Once you agree on that platform, then the issue is how to manage, how to really handle and manage the risks. And it all boils down to an area that, in my personal view, and we have seen a fair amount of infrastructure projects in South America, Asia, Europe, it boils really down to the simulation, running of simulation of the mathematical formula of the financial plan, and whether that financial formula does have caps and floors, and whether representations and warranties match those caps and floors or not. So is there a cap on that risk, on that flow? Should there be a maximum cost that I can incur, or there is no cap on that cost in the formula? And that it's an area of this block of project finance that needs to do a lot of homework, let's put it this way. And we have gone through personally through supercomputer simulation with the Cray machines, and it has indeed shown the limits over a 20 to 30 years plan. So trying to wrap up, basically my key point is I think there is a strong positive element in a unsolicited offer. B, there is a strong possibility of adoption, regardless of the jurisdiction, of the first refusal project financing that I've mentioned. There is a strong need for a timely administrative court to address, and despite what are a number of comments and beliefs, a number of jurisdictions, including Italy, you can get a 15 days summary judgment, first level, and you can get a 7 days summary judgment, second level administrative court. So in general, global banking terms, that's an excellent state, let's say, possibility to let's say, have a certainty of law within a very short time frame, anticipating costly arbitration. And we're talking a summary, then merit, but merit could be postponed to maybe one year and a half, but by then the decision between the two parties is a yes or no whether to go on. There is always a settlement after the summary judgment. So positive to have, in my view, unsolicited offer, interesting first refusal scheme, possibility to study and adopt a platform and replicate that platform. The applications have been infrastructure, services, and infrastructure. The recent January, February directive packages reviewing the initially 10 years ago preceding packages does evidence the concession part. It's a big concession for services part, which is a big improvement on a very just try to imagine you have a main mall in the city disrupted. You just want to have only a services concession. The European legislation was fairly poor in that services concession, which is the maintenance of a number of goods that could be refinanced and restructured. That's being addressed in a much more solid way today. And I think there is a lot of scope.
Спасибо большое, Марк.
Thank you very much, Mark. You've told us about the real practice in the implementation of such a form of an offer or a contract form that is very relevant today in the Russian Federation. It hasn't yet been used for a single time, but these amendments in the concession agreements and laws that Dennis discussed they are introducing rules according to which concession agreements can be made based on a potential concessionary's offer. So procedural issues when a refusal is possible to such an offer. What's the tender procedures, and what are the requirements for the parties involved? How costs are being reimbursed for the participants is what Marco discussed. And what infrastructure projects in general can be covered by such a procedure is a very relevant topic today. And the key reason why this exists is, I would put it this way, is the weakness of the administration, the regional administration in the first place, in the preparation of concessional contests, competitions for projects that really are lacking infrastructure financing. And this weakness brings about the lack of desire by the market to prepare projects of their own, including business plans, financial models, and text to the concession agreement. So, and to be fairly objective and open in this procedure, of course, what you need is for this procedure to be described formally, in significant detail, for the investor to have their costs reimbursed. Marco, I have a question. Are there any limits, restrictions in terms of the size of the project, the cost of a project, or that could be multi-billion projects?
The answer is, at the moment, no. The limits that we have are in terms of duration and proportionality between the long-term and the financial plan, whether the financial plan justifies the duration. This is to say, if I'm in a project, I try to obtain as long as plan as possible. And the question is, does the asset and is the flow deriving from the asset justifying at 30 years, or given the work you're committing to do, given the activity you're committing to do, given the obligation of maintenance you're committing, is all that justifying something in excess of 20 years? This is what we're seeing. And it's let's say, a relatively primitive approach to a very correct way of handling a public good. To get to the first point of your question, Milano-Brescia, Brebemi, arguably one of the largest, 56 kilometers, 885 million, now up to 1.560. It's gone, it started, we were fully involved from the early beginning in the project financing structuring. It took a team of maybe engineers, we're talking maybe 50 people, plus legal advisors. So that's one of the largest that we have seen in Italy. There is a very large one in excess of 3 billion that has been obtained for a central highway treat north of Rome, going up to Bologna. And then the other examples are short pieces, Foligno and Torino in the 30 kilometers, 300, 450 million euro.
Да, спасибо большое. Но вот видите, да.
Thank you very much. Those are fairly major projects that can be covered by this procedure, something that we could have if we have the legislation. By the way, the draft PPP law has a detailed description of the procedures related to such market offers, with the basis for refusals and what happens if the public authority believes they have the right to exist. And let's see, maybe we should look more detail into the practice in the European community with these projects before we adopt those in this country. I would like to discuss another financing instrument for the financing of major infrastructure projects: infrastructure bonds. Infrastructure bonds are a fairly new but very relevant topic today, a relevant vehicle or mechanism to finance projects. We don't have many examples where bonds were used to finance projects. Usually these are projects made by companies around pension funds. It's clear why, because there's demand for investment on the part of the pension entities, and the limits that we have in the legislation with respect to the investment of pension funds into infrastructure projects are considerable, but still, as far as we know, changes are being made as we go, and the focus of the government is to uncover the opportunities for the financing of major, well-structured infrastructure projects at the expense of, or thanks to pension funds. So I'd like to ask Elena Glenikolini, a partner from Denton's. According to your practice, what can you see? Are there opportunities to extend or expand these projects to be financed not by traditional bank loans or stockholder equity, but using infrastructure bonds, or bonds that could be bought and sold on the market and distributed among private owners?
Thank you, Aleksey. Just to answer that question, I think we have to think of or introduce additional mechanisms to bridge the gap between the requirements for infrastructure finance in Russia and the ability of the private sector to finance those projects. It's a huge gap. The amount that's required, according to the government's own plans, exceeds the financing capability by at least a factor of 10. And moreover, we need to think of mechanisms that utilize, that proceed without the intervention of the government. In other words, without the support or guarantee of a government entity. Again, thank you to the organizers, and I'm also very happy to be here in St. Petersburg, now based in Moscow like Aleksey, but based for many years here in St. Petersburg. And looking at the window, I see that the winter weather that we had last night seems to have dissipated and it's become summer again. Anyway, let's start. And I think maybe the most interesting thing of talking about municipal bonds is to see that it really can be an enormous, just a vast source of financing. And this is an example in the U.S., which is probably the largest market for municipal debt. I should say that municipal bonds in the U.S. date back almost 200 years to the construction of the Erie Canal in the northern part of New York State, connecting the Hudson River and the Great Lakes. But they really started to pick up after the Second World War. In 1945, there was only 20 billion of municipal debt outstanding, whereas in 81 there was already 360 billion, and now the amount is almost $4 trillion. So it's really a vast amount that can be raised with these mechanisms. I should point out that these figures are a little bit misleading because they include both municipal project debt and municipal revenue bonds. So for instance, of the 4 billion, a little bit less than 2 billion are actually project bonds. And some of the advantages of municipal bonds as they're used in the US and to a certain extent in the UK, it's particularly suited to financing large projects with low returns and long payback periods. And one of the things, going back to Aleksey's question, that's quite interesting is that in many of the biggest projects, they can't be financed solely with a bond issue, but you can combine various mechanisms, PPP mechanisms, or even standard project financing, equipment financing, together with municipal bonds. The biggest attraction for municipal debt in the U.S. is its tax exemption. If it complies with federal law, it's exempt not only from state and local taxes, which seems rather clear, but also from federal taxes. This enables the municipal entity that's financing the infrastructure project to pay a significantly lower coupon rate to the investors, thereby lowering the cost of financing. And another factor that's quite important is that unlike issuance of other types, for instance, of corporate debt or of securities, there is an exemption from SEC review for municipal bonds. As I already alluded to, one of the key factors is that it's a limited recourse obligation. So the obligation is, except for certain things like preserving these, the integrity of the reserve funds and the debt service funds, the local government has no recourse on the debt. The debt is repaid by the project. If the project, God forbid, has a problem and doesn't repay the debt, that's not the obligation of the government to step up. And I'll come back to credit enhancement mechanisms. And another important factor is that the rules for the issuance of these bonds and the terms of the bonds are set by a self-regulatory organization, which is called the Municipal Securities Rules Board. The type of projects that can be financed with tax-exempt debt is limited. It's supposed to be projects that can't be financed in more traditional ways. So, for instance, there are transportation projects, there's low-income housing, parking garages, hospitals and clinics, sewage and water treatment. But I must say that people are creative, not only in Russia, but even in the US. And many times a particular developer coming into a community will convince the community to issue a bond specifically for the project that they're looking at. This is particularly common with sports arenas, which maybe aren't the type of projects that should be financed, particularly with municipal debt, but again, often lead to a revitalization of downtown depressed areas. And in order to make these bonds attractive to investors, and by the way, they're not limited to pension funds, although, of course, pension funds are one of the important sources. In fact, even small investors oftentimes have in their portfolios municipal bonds, which are denominated in very small amounts, sometimes even $1,000. But in order to make them attractive, there are a number of mechanisms that are used. First of all, from the proceeds of the bond issue itself, a number of funds are set up, such as a debt service fund and a reserve fund, to assure the repayment of debt service. And in addition, many of the bond issues are enhanced with insurance policies, such as issued by the Municipal Bond Insurance Agency. Some of the obstacles for municipal bonds in the traditional sense, and I should say that, as Aleksey alluded to, there have been several issues of infrastructure bonds in Russia. They're somewhat different. These were somewhat different. For instance, they're not tax exempt. They're the direct obligation of the issuer, and they have been used to date on major road projects, major transportation projects, such as the M1 exit to Domodedovo. So some of the things that would be needed to introduce the type of municipal project bonds that are used in the US, for instance, and the UK, would be, of course, amendments to the tax code to permit tax-exempt income to be received by the investors. This, to me, at least, seems like a logical thing in the context of Russian investment law, because, as you know, it's quite common for subjects of the Russian Federation, such as the city of St. Petersburg or Leningrad Oblast, to enter into investment agreements pursuant to which there is tax relief from the local portion of taxes contemplated. So it isn't a completely foreign notion, it seems to me. As Aleksey noted, one of the key issues is to permit things such as pension funds, particularly pension funds, but other large public funds to be invested in municipal bonds. And the need for an overall legislative framework. Coming to the legislative framework, you probably have seen that for several years there have been draft laws suggested. The most recent one dates back over a year, about a year and a half. And the law has a very, very long list. The draft law has a very, very long list of the type of projects that can be financed through infrastructure obligations. In my mind, the list is too long. So, for instance, it includes things that clearly should be financed in a more traditional way, such as oil and gas pipelines, oil refineries, things like that. And it needs to have more of a focus on really things that can't be financed traditionally. Low-income housing, heating, kindergartens for children, clinics, hospitals, those sort of things which are quite difficult to finance. Under the draft legislation, the issuers are to be special project companies. This is the way that Russia has generally proceeded with infrastructure financing. In the US, the concept is somewhat different, and there are pluses and minuses, I think, of both systems, but the US system is to have permanent authorities. So there's, for instance, the North Carolina Housing Finance Authority, which is an issuer of hundreds of billions of dollars of debt over a period of something like 30 years to finance low-income housing in North Carolina. These agencies and authorities set up by the states to issue municipal debt develop, of course, their expertise, and the people who are working on these projects and are getting this training, just like people like Aleksey, who got his training here in St. Petersburg, it becomes a sort of an infrastructure of its own, of the expertise that is needed for these very difficult projects. And again, in the draft legislation that's been proposed in Russia, the securities would be treated as Russian securities, in other words, as cенные bumagi, so it would be subject to all of the same securities regulations that corporate debt and other securities are subject to. So again, I think that this is an important area for relief. No tax exemption, and it contemplates guarantees by either the federal government or the subject of the federation. Now, guarantees are certainly a familiar instrument and a good thing in many respects, but one of the issues that comes up in the draft legislation is that it provides that the guarantees of subjects of the federation must comply with the current budgetary codex. And in effect, this means that most regions would not be eligible to issue municipal debt. But again, remember the contrast with the US, where we have limited recourse debt, no recourse to the issuer. It should be possible to use this mechanism even in regions of Russia which are running a deficit budget. So very, very important point, I think. So that's really all I wanted to say today. It's our theme for today is classics and new instruments. The municipal bonds or municipal project bonds is both. It's a classical instrument. It's an instrument that has a history of almost 200 years. But in Russia, it's a very new instrument, and we're just beginning to feel our way forward. We have a few issues, large issues for transportation that were successfully done. We have a draft law that needs a lot of work. And it seems that it's the discussion of the infrastructure bonds and municipal debt has decreased in the last year or so, and more focus on on other instruments, which I think is regrettable, particularly because of the flexibility of this instrument and the ability to combine it with other types of financing to solve the problem of both the very large projects on the one hand and the projects with very low returns and long payback periods like clinics and kindergartens and things like that. So with that.
Спасибо большое, Глен. Вот действительно там.
Thank you very much, Glenn. We do share Glenn's regret over the failure to use infrastructural bonds, and I share that. And I have one provocative question. We don't have Ministry of Finance representatives here, so I can only address it to Konstantin Popov, who represents a government or a quasi-government structure. In your after-door projects, almost all of them, there's a government grant or budget financing provided. Glenn has told us that in North America, a different mechanism is used for the same purposes, bonds issued, municipal bonds. Have you ever discussed it with the Ministry of Finance? I know that Afterdoor has attracted corporate bonds, and we were one of the organizers of such an issue. Why don't you discuss financing with the help of government bonds or after-door bonds? More than that, we have never stopped discussing this issue. Our government company has a successful experience of placing its own papers in the market. Moreover, the Central Circular Highway is partly financed by the National Wear Fund, and this is partly taking the form of after-doors bonds. It's not quite market styled mechanism, but it's payable, and the coupons begin to accrue and are payable. And the government companies have tested this financial model and have been audited by financial authorities and the Big Four experts. And the repayment comes from tolls collected by the government company. It's a non-market instrument. It's custom-made solution. But a grant is issued when it's clear that a project can't move without those subsidies that can be returned. And we know that one city of federal significance has announced a concession with no government support, with no federal support. And we all know what the project is. So we all wish it every success. We know that 3 entities have decided to take part. But the main problem of the infrastructure is that very few projects have economics enabling the full repayment, the full debt repayment, no matter what kind of syndicated financing or securities issue are involved with no government support. But I don't think it's an alternative. These are instruments that should complement and support one another. Thank you, Konstantin. I was also going to ask Igor Gorchakov, Allen and Overy partner, specializing on infrastructural financing and bonds. Do you see any prospect aspects in the change of the legislation to enable infrastructural bonds to acquire greater importance. Today, it's just one highway road, M1 exit to Odintsovo, and a couple of sports arenas with bonds bought by pension funds by 100%. What changes do you see as necessary, and or maybe what examples of such improvements can you cite? Thank you, Aleksey. You know, fortunately, we have good news here. And as regards infrastructural bonds or project bonds, so far not municipal but private bonds, we can not only say there are promising, well, there's the promise of changes in the legislation, but there's already a whole package of laws, the so-called December package, which is coming into effect from July the 1st this year, that is 2 weeks from now, actually, and this will include a few new instruments targeted at mobilizing money for project financing, which could be used in transactions that are only envisaged and also in those that have started.
Could you speak a bit louder, please? Speaking about this topic, in the beginning, I would like to discuss new possibilities in line with this new legislation. Looking at this new law, we see that those people who developed it, they used international experience, especially, for example, if we take some requirements of various international rating agencies where they have a checklist of what should be included into the structure in order to get its ranking and for investors to invest in these securities. So this checklist and all requirements you may find in the new law. What are the major interesting things? First of all, this new law, and especially its part that introduces amendments into the securities market, we see that there's protection from bankruptcy for the emittent, and a bit later I will speak in detail what are advantages of this, especially in terms of such transactions. In this law, there's a wide range of different types of securities for infrastructure obligations. Igor, are you speaking about amendments in the Civil Code? Actually, it's amendments into a number of documents, and law on bankruptcy, the law on notary services, and even the law on court decisions enforcement. So when we speak about this, I would like to specify exactly that there is a clause on escrow account. These are project accounts, and traditionally there has been a problem with using such accounts in Russia, and the only available mechanism was actually withdrawing funds from the current account. Now it is a different situation. Now we have this new new institution of these project or escrow accounts where revenues can be accumulated. And if we speak about obligations themselves, now I'm speaking about amendments to the law on the securities market. Here again, there are novelties and new mechanisms that allow to be more flexible for the specifics of different projects. For example, there can be different tranches. We can introduce changes into the requirements of issuing these bonds without preliminary registration. We don't have very much time, so I will skip some of the slides. If you have any questions, then I will be happy to answer them. And now, very briefly, about the pledge. Any assets can be used as a pledge. First of all, this requirement that relate to future terms of future contracts. So this was always a problem. So can we use as a pledge some future terms of future contracts? So here we see that it is possible to do it, and this will be especially interesting for projects where at the stage of implementation, at the stage of construction, there are no payments and no revenues. So these terms or obligations are a matter of the future. And sometimes these payments will come only in the future. Now, this has been regulated, and it is possible to use this as a pledge under these transactions. Now, a couple of words about this SPV structure, special project vehicle, and why infrastructure obligations issuance, and actually they will be issued by this SPV in order to attract project financing. Why there will be demand for that? Because this is a special vehicle protected from bankruptcy, because it has limited functions. So they can only finance long-term projects, and long-term it means more than 3 years, long. And this can be done by purchasing various obligations and also issuing bonds, obligations. In the articles of incorporation, there can be additional constraints of the rights of functions of this vehicle, and this gives guarantee to investors that this structure will not be obliged to pay to some other financial organizations. And this these limited rights, if we compare, for example, similar transactions in Europe or the United States, it is one of the most common requirements for a transaction to take place. Another interesting thing I would like to note, as for management of this SPV, it is taken not only by the shareholders, but they can be those obligation owners. They can take part in taking decisions and managing this SPV. And this is, of course, extremely important for this. And there will be representatives representatives of shareholders or obligation holders, and they will be performing certain functions, and they should approve certain transactions when this is required by the law. I also would like to mention two very important things that are stipulated by the law, and this is both the law on bankruptcy and the law on securities market. And if we speak about international rating agencies, for such transactions and for such obligation issuance, this is a must in order to get this ranking. This is a limited recourse requirement, and a second is a non-petition constraint. So let's first have a look at this limited recourse clause. It's one of the key elements of international project financing. It means that investors who invest their money in a project, they should understand that the security for them to return their funds are only assets of the project. So no other assets can be used as such a security. No other guarantees of sponsors of this project can be viewed as security in this case. And this provision protects sponsors of the project and investors, because there's no competition for such other assets, and investors don't have a possibility in some way to sue a project company or to recover damages from other assets. So everyone is in equal position, and if project assets are not enough, then nothing happens. So everything closes. The second concept, this non-petition concept, it is limiting possibilities to file an application about bankruptcy. This means that those who can be financing SPV, if they sign an agreement for financing, so this can be any loan agreement or other types of agreement, so they are limited in their right to bankrupt this SPV. So loan givers joining this deal, they see that no other entity can call this project company bankrupt. And speaking about Europe, in most advanced countries in the area of securities, especially if we take Ireland, for example, where we see that lots of obligations are issued, this provision does not exist. So we are ahead of many European countries in this regard. I have already mentioned that SPV structure, one of its functions is purchasing of these obligations, and these are obligations under future agreements, and this is through actual purchase. When these obligations are acquired by SPV, then any other entities who provided financing, they cannot require them to transfer these obligations. Okay, we are quite short time. I would like to mention two more concepts. First of all, these are representatives of obligation holders and also project or escrow account. This figure, representative of obligation holder, this notion was introduced into the legislation a couple of years ago, and that was at the time of the financial crisis when poor shareholders and obligation holders, didn't know what to do, and the emittents didn't know what to do when they had to deal with 20 or more obligation holders, how to sort it out, and they wanted to have some sort of guarantee that no one will sue them in the future. So for this new institution was introduced. It is a representative of, it's similar to the British bond trustee, and all legal and other sorts of actions between the obligation holders and the emittent. They sort out all issues. These representatives can, under such transactions, when we speak about infrastructure obligations issuing, they can manage security, and this is a very convenient figure both for financing organizations, so they know that they can recover damages through this person very quickly, and for the emitting parties, they know that if there's a need to restructure the debt, then they should contact these people. And one more concept I wanted to touch upon, this is a project or escrow accounts. Three major types I would like to underline. First of all, if such a project account is created and if revenues hit this account, this account cannot be closed, so the owner cannot file an application to close this account. No, it will remain open for the whole period of the project. Secondly, there should be a certain balance on this account, because this creates this guarantee for payment, and the bank can control actions of the account holder. For example, if the account holder would like to withdraw a large sum from this account, the bank may reject this requirement. And one more thing, if there is a case that gives us the right to take this money, then it is done very simply. So the party who can do that, they simply withdraw the money. So all these things are demonstrated in this chart. Here you can see. So the obligations here are issued not by the grantor, but by the SPV. So they purchase these financial obligations. For example, this may relate to revenues, tolls, or maybe it is availability fee that will be paid, and they issue infrastructure obligations. It is also possible, and this is in line with the law that will become effective as of the 1st of July. We also could think of structure, LP structure, loan partnering, and here the law does not refer specifically it does not refer to such loans. Now, colleagues interpret it in a different way. Some use a broader interpretation. Some believe that it cannot be done. We'll see in practice whether this is possible or not. And now a couple of minutes about syndicated loans in line with the Russian legislation. It's not widely used method because the judicial practice didn't allow to have this syndicated loans using the structure typical for international projects, LMR, for example, models. Now, in view of the amendments to the law, lots of issues have been cleared. For example, management of the pledge and the multiple representatives of this pledge owner. So we needed to have a Russian similar laws, similar to European or American LCTA legislation. So in 2011, the Association of Banks of Russia established a task force for a development of such model draft law. And now we see that these amendments have been introduced to the Civil Code, and from September 2012, a model agreement since December 2012, model law, a model agreement has been prepared. What is it? So we use the LMA, single term facility agreement. Yes, it is for developing countries, and this means that this is a simplified model of this agreement, and we have taken out some provisions that are common only for the English situation. So this is not an English law, it's a Russian law, and it uses all terms of the Russian law, and all the terms of the Russian legislation are being used here. And this agreement can be used by Russian banks or international banks. And the draft law is in line with the amendments to the Civil Code that will become effective from July 2014. We can further discuss it in August, and we hope that the market members can use it. So we have bright future, and I would like to wish to all of us great projects where we will be able to use these novelties. Thank you, Igor. Thinking about all these amendments to various laws, I have quite an ambiguous opinion. For example, all this security concept and using pledge, and this was important, and it was necessary for all the projects and these future revenues. This is true about these projects when the loan holder, they don't have any assets, and all revenues are in the future. So that was a key thing for creating project or escrow accounts. Speaking about concession projects, so this SPV, what is it? Is it a concessioner, concession holder, or is it a standalone society, a company that finances the concession holder, gives financing? We believe it is the second case, because this is better to use it as a separate SPV, separate society for the concession holder, to be able to attract other forms of financing, for example, loans.
And the law, by the way, enables you to agree on the sequence of requirements, not just within your issues, but among the different issues. Okay, I see. Thank you. Igor has mentioned that based on this model agreement, or the LTA model, there's a standard contract been made. Now, I'd like to ask Igor from Gazpromneft. It's no secret that many major projects you're doing are not structured according to the Russian law, and the changes adopted recently and the entire trend is to improve the flexibility of our civil law on securitization and the stock market. So do you believe this will encourage major projects like construction, infrastructure,
приближении
to
переходить уже в российскую юрисдикцию? То есть достаточно ли таких
be brought into the
экспериментов?
Russian jurisdiction? Is the flexibility sufficient? Thank you, Aleksey. Good morning, dear colleagues. I'll try and be very brief to tell you about the legal concepts used in the implementation of major construction projects, including infrastructure, using Western models. Talking about the practice of Gazpromneft, our contracting strategy is based on the use of Western models to a great extent, particularly upstream and downstream. But now, upstream is more or less clear. There's no other way of doing it. How to use Western contract forms. Russian downstream does arouse certain issues, but still the experience we're studying from other companies is that Western models have become part of our lives already. And there's quite a few reasons for that. A balance of forms. The risks, including legal risks, are borne by the party, not the party that can manage the risk, but that can monitor and prevent the risks. Another point is that they're all universal. Any construction project can be built based using this form. Now, another important point is the practice in the use of these forms during many years. There's a Federation of Engineers Consultants, the so-called FIDIC, has been in use since the 1950s, and it's now used fairly broadly in construction of major projects. And then, of course, you shouldn't forget about the popularity of these forms, because it's no secret that major construction projects are being implemented with the involvement of Western construction engineering companies, companies that provide consulting, and of course all these companies are easier to agree with using the forms that they are used to. Now, talking about the forms, these are FIDIC forms. They're the most known. This is a center of harmonization of such forms, but they're not the only ones, because you can take, for instance, the standards of Orgaline, the European Association of the engineering industry, then ICE, the Institute of Civil Engineers in the UK, and they're used alongside with FIDIC in terms of methodology and structure, and most importantly, they have provided a lot of content for the FIDIC forms. Now, speaking about the difference, why the Western contract model, there's this, the classical construction contract. We kind of tried to explain this through the wish of the customer, what the customer wants, the project. The customer wants the project to be built, or the customer wants to have a company that would provide quality and can integrate the project, can bring together all the processes in the project and manage them effectively. So to avoid misunderstanding, this chart shows you not the structure of relations, contractual relations, because it's clear that, of course, EPC contracts, they're, of course, different. But we tried to show you the management in terms of project management. Major projects require integration anyway. Question is, who's going to do it? Because classical integration, we think that it's up to the customer. The customer will have to do it. Nobody else will do it. The Western contract model enables you to delegate the bulk of these functions to your Western contractor. Now, speaking about the forms, and again, let's take the most known forms, the FIDIC ones. The most two well-known in Russia are EPC contract, which includes turnkey construction, and ECPM, which is design, build, and procurement management. So these are used in world practice, and as far as we can see, the recent trend, some hybrid models are popular. Something in between of these formulas. Taking the practice for our company, we have one construction project now implementing it based on the EP plus CM model. That's when the customer has a contract with the engineering company, the one that provides the delivery of equipment and management of the construction. And then all construction work is in a separate contract. So you have this a circle of players. The purposes are different, of course. You can cut costs of your project, diversify responsibility, and so on. Speaking about recommendations for applicable law, in terms of course, we do support the idea that projects in Russia should use Russian law as much as possible, but still we have to accept that foreign law, let's take English and Welsh law, protects the interests of the parties much better in such complicated construction projects. There's quite a few facts to support this. Construction is more or less okay, but if you take other contract obligations, it becomes much more difficult because, you know, in a major construction contract, your obligations, the contractor obligations, are not limited to construction alone. There's a lot of services and many other things. For instance, if you take Russian law, there's this issue of qualification of duly performance. Due performance. What's due performance under Russian law? That's unclear, even though it's pretty clear under English law. That's about guarantees and indemnities that I honestly, in many years, don't even know how to translate that into Russian, literally. All these instruments are unclear for the Russian law, and they are very important for major construction projects. There are issues around reference to international standards, like correlation, direct references in a Russian contract, and in terms of English law, you know, what's best engineering practice, you know. Then there are advantages in Russian law as well, like you don't need to hire external experts, experts in English law. So you're in terms of capitalization of your project. And then I wouldn't like to finish off on a negative note, because if you think of this as an opportunity, a prospect that needs to be changed in our legal framework, because I had some hopes that changes in the civil code will be about chapters 37, 39. That didn't happen, but now back in 1991 we had the State Construction Committee that enacted an act describing what's a construction contract. So we were very close to the philosophy that is contained in the Western contract models. We kind of lost it in history somehow, but with time I think we'll get there. Thank you very much, Igor. Indeed, project financing always raises the search of a the issue of searching of a contractor, an integrator, who will be responsible for all actions under the entire contract, starting from design and design control, and to down through all the way down to the operation, the specifications and everything around that. Now, dear colleagues, we have tried to stay within our time limit and discuss all the items we have. We have just a few minutes if you want to ask, if someone wants to ask a question or just make a brief statement. So if anybody wants to ask anything right now, if not, I'm sure all speakers will be happy to do some networking offline. And I think we've generally reached our goal. We discussed changes in the contracting system and project financing. So I thank all the participants to this discussion and hope that your further participation in this forum will be helpful to you. Thank you.